I'm going to give it one more minute and then I'm going to get started. So people are dribbling in. I should put up my share screen.
You can go first. You can try. There we are. Perfect.
And then there we go. I don't know. I can see myself on my.
Yep.
Okay. Now I don't have my watch. Okay. I have 11 a.m. Eastern time, and there are constant attendees dribbling in, and I can tell by the number that they're going to keep doing that for the next few minutes, but I'm going to get started so that we don't cut James short, because we all know he is the rock star that everyone came to see today.
Too kind.
So I'm going to get started. So welcome to our annual year in review webinar. I'm here with the amazing James Netto, and we're going to share some of the top international family law updates from 2022. And I'm going to start today and provide the US updates first for about 40 minutes, and then I'm going to turn it over to James, who's going to provide the updates from his side of the Atlantic for the rest of that. And it is always a very full hour and a half, so we're always really grateful for your attention and your time. There is a chat feature, there is a Q&A feature. You can certainly pop questions in there, but I cannot promise that we will get to them. However, if it is directly to us, you can certainly let us know. We can follow up with you after the webinar if we don't get to the questions now. Okay. So today's first update is from the Hague Conference on Private International Law. Its governing body, the Council on General Affairs and Policy, meets each March. The Hague Conference's experts group on parentage and surrogacy will present its final report to Council at Council's March 2023 meeting. This final report recommends that Council establish a working group to explore provisions for a new convention on legal parentage and a protocol on legal parentage resulting from surrogacy. You can read the report at hcch.net, which is on the screen. In 2022, the Hague Conference held its very first special commission meeting on the 2007 Child Support Convention and its fifth special commission meeting on the 1993 Adoption Convention. The Permanent Bureau, which is the General Secretariat of the organization, is preparing for a meeting of the International Hague Network of Judges in Singapore, the first half of this calendar year, and a special commission meeting for the 1980 and 1996 conventions in October of this year. The Permanent Bureau publishes preliminary and preparatory documents for each of its special commission meetings, and that can be found at that website as well that you see on your screen. And the next update, the U.S. Department of State issues a yearly compliance report, which I call the naughty list. As mandated by Congress, it collates all outstanding child abduction cases from the United States to another country and explores some of the underlying reasons why those cases are still unresolved. The report includes both countries where there is a treaty relationship and then those where there are not a treaty relationship with the United States under the Hague Abduction Convention. So there may be countries where there are no laws in place between the United States and that country on the list. It looks at statistics for the year prior to it being issued. And then it lists these non-compliant countries, which is defined under the International Child Abduction Prevention and Return Act. That's the federal law that mandates this report. For the most part, the countries in the most recent report, and the most recent report was put out the summer of 2022, which looked at 2021. So we can expect that this year's report in a couple months. It generally mirrored the prior year, except that there were a few new countries added to the list and none removed. And those new countries include Austria, Belize, Honduras, South Korea, and Trinidad and Tobago. So the compliance report can be found by going to travel.state.gov. And then we're going to move into some of the cases. And most of last year's international family law updates in the US came from cases brought under the Hague Abduction Convention. There was a fifth US Supreme Court case, which I will touch upon, and that James Netto here authored one of the amicus briefs for that case. Okay, so first on the issue of habitual residence. When the US Supreme Court handed down its opinion in Manaski versus Talieri in 2020, it not only set forth guidelines that the court needs to look at the totality of the circumstances when it's assessing a child's habitual residence, but it also stated that a trial judge's finding of habitual residence can only be overturned when there's a finding of clear error. And this had, in many of our minds, actually made it very highly unlikely that an appellate court was going to overturn a trial judge's finding of habitual residence. But then comes 2022, and we've had two appellate opinions, but they were both out of state appellate courts, not federal courts, that overturn their trial judges' habitual residence findings. So on March 23rd of 2022, the Court of Appeals of Texas reversed an order that required the return of two children to Israel. The father, who was a former Israeli diplomat, and the mother, an American, met in Florida and married. Shortly thereafter, the mother became pregnant. During her pregnancy, the father returned to Israel. He then told the mother that they were no longer married under Jewish law because he believed that she had lied about being Jewish in the first place. At 32 weeks pregnant, the mother then flew to Israel on a tourist visa. The father would not allow her to live with him, and so the mother attempted to return to the US, but she was prohibited from flying because she was advanced in her pregnancy. She visited a doctor to obtain clearance to fly, but then she went into labor and had twin daughters born in Israel on June 20th, 2016. On November 8th of 2017, over a year later, the parties agreed to a Jewish divorce, and the Israeli courts set out a visitation and support obligation for the father, and it required the twins to live exclusively in Israel. The mother, unable to work, not speaking Hebrew, having no personal items in Israel, she told the father that she wanted to return to the United States with the children. That prompted the father to go to court and obtain a ne exeat order for each twin in February of 2018. The mother claimed she'd never had notice of that. And so in April of 2018, the Israeli government ordered the mother to leave because she had overstayed her visa by quite a while. The mother obtained US passports for the twins at the US Embassy and told the consular officer that no court had ever issued an order or decree that referenced the custody or the travel of the children. The mother and the twins left Israel for the US that month, and in August of 2020, the father filed a return petition in the Texas state courts under the Hague Abduction Convention. The mother represented herself at trial. The trial court ordered the twins returned, but on appeal, the Texas Court of Appeal focused on the fact that when the father returned to Israel, he considered himself an unmarried man, leaving the mother pregnant in the US, and that he even questioned the paternity of the children a year after they were born. He refused to let the mother live with him when she traveled to Israel. The mother, when she signed the custody agreement, did not understand it because it was not translated. And the fact that an Israeli court established custody in a court order did not in isolation establish their habitual residence. She was unable to legally remain in Israel or obtain employment. So further, she tried to return to the US and give birth, but the airline prohibited her from flying. So when she returned, she was still breastfeeding as well. And on that basis, the Court of Appeals reversed the habitual residence finding that Israel was not the children's habitual residence. And just a reminder that this is a Hague Abduction Convention return proceeding. It's not an action to register the Israeli custody order in Texas under the UCCJEA. That would be a separate proceeding. Similarly, the Court of Appeals of Indiana concluded that its trial court committed clear error when concluding that Germany was the habitual residence of two US citizen children. The parents and their children lived in an apartment in Germany from 2017 to December 2020. In 2019 and 2020, the parents had a number of conversations about a trip to the US and even about the possibility of moving there. They agreed to an extended vacation to the US to get a better idea about whether an actual move might work. They agreed that they would live with the children's maternal grandmother in South Bend, Indiana, at least initially. The father sought a U.S. permanent resident card. He represented that the family was planning to move to Indiana. Once receiving that permanent residence, the father terminated their German apartments lease, liquidated assets, and arranged for shipment of their property to South Bend. They transferred the bulk of their money to a South Bend bank. In a customs declaration, the mother even represented that the family was moving back. But the family also purchased 8 weeks of travel insurance to cover their medical needs in the US. They registered a new apartment in Germany with the German government as a home address for all their family. They renewed their German health insurance. And in 2021, in January, the father sought to return to Germany, but the mother disagreed. The father had believed that they had agreed that they were going on an indefinite vacation that would end if either of them wanted to go back to Germany. In February 2021, the father returned, as was pre-planned. They continued discussing whether the whole family would go back. And in April, the father returned to South Bend, rented his own apartment, but he was unsuccessful in getting employment. So in May of 2021, he went back to Germany again. In June, he petitioned for divorce in Germany. The mother petitioned in Indiana. And on July 15th of 2021, he filed his Hague abduction return petition in Indiana. The appellate court ultimately reversed, saying the children moved to South Bend in December by agreement of both parents. While both parents might have not seen eye to eye with respect to the circumstances under which the family might return to Germany, the facts are clear that they both saw that the move to the US was indefinite and at least possibly permanent. So Germany was not the habitual residence that had shifted to the United States. So a respondent parent has several arguments against returning their child to the child's habitual residence under the Abduction Convention. One such argument is that a child is mature and has objected to being returned. Much like 2021 and 2022, the court saw an increase in judges conducting in-camera interviews of children. Often when a child was interviewed in chambers, however, the court also had the benefit of some type of mental health professional who had also spoken with the child and provided an opinion to the judge. For example, the federal court in the Middle District of Florida returned 2 children, 9 and 13, to Canada after having interviewed each child in chambers with a court reporter, law clerk, and Hannah, the children's golden retriever. Separate from the in-camera interview, the court also had a psychologist interview the children. The court concluded that the youngest child had no particularized objection to returning to Canada, only a preference to remain in California, which is actually where they were living at the time of trial. The court also concluded that the oldest child did not object to returning to Canada, was mature and was not unduly influenced, and that the exception only ended up it only applied to one of the 2 children, meaning one must be returned. The court they focused on Article 18, and that gives the court discretion to return the children at any time. Therefore, since the court felt obliged to return the youngest child, it just chose to return both of them as well. So this is an interesting case out of the 8th Circuit. It overturned a trial court's refusal to return a 12-year-old to Switzerland. In this case, the judge interviewed the child in chambers after a psychologist concluded that the child was mature. During the in-chambers interview, which was conducted in English, even though that was not the child's first language, the judge helped the child along by trying to explain the difference between an objection and a preference. And the judge would say things like, I object to cleaning the bathroom, or an objection is something you don't want. You're displeased. One is stronger than the other. Ultimately, the trial judge concluded that the child objected to returning to Switzerland, but the 8th Circuit actually saw it very differently. The Court of Appeals concluded that the child had no particularized objection and that their mere preference was just to remain in Missouri. The Court of Appeals remanded the case and gave the court instructions to the trial court to promptly return this child without any further proceedings. This case illustrates the issues with judges conducting in-camera interviews. I mean, this court had the same exact script, both the trial judge and the Court of Appeals, and reached very different ultimate conclusions on what the child was saying and whether they objected or not. What also was very concerning about this is that the trial court actually resolved this case in only I think it was about 10 weeks, very quickly, relatively, but then the actual appeal took almost 2 years. So the child was not returned initially, and then after 2 years of sitting in Missouri, the child was then returned back to Switzerland at a much older age, and after having actually been part of a Missouri community for a while. Okay. So this is the big one. One of the most commonly argued exceptions to returning a child is that doing so would expose the child to a grave risk of harm or place that child in an intolerable situation in the child's habitual residence. Some U.S. circuits, even after finding that a grave risk of harm existed, were required by precedent to examine whether there were things that could be put in place to ameliorate the risk of harm so that the child could go back to their habitual residence nonetheless. And that was the issue that was at the heart of Golan v. Sada. On June 15th of 2022, the U.S. Supreme Court decided this case. In this particular one, the Eastern District of New York judge found a grave risk of harm if the child were returned to Italy. But the Second Circuit had precedent that said that this judge was then required to consider whether there were ameliorative measures that could safely return the child. The judge found ameliorative measures, and so the child was ordered back to Italy. After several appeals, Ms. Golan then appealed to the U.S. Supreme Court, as she was granted, had her certiorari petition for certiorari granted. And the issue was for the judge, or to decide whether the judge should be mandated to consider ameliorative measures. Ms. Golan took the position that in cases of domestic violence, ameliorative measures to safely return children are almost never appropriate. Mr. Sada took the position that exploring whether there's a grave risk is inextricably intertwined in analyzing ameliorative measures in the first place. So one has to examine ameliorative measures when examining whether there's a grave risk of harm. The Supreme Court decided to go a different route. They concluded that a judge has the discretion, but is not mandated to consider whether ameliorative measures exist to safely return a child when there's otherwise a grave risk in doing so. The court framed ameliorative measures as a consideration in many cases, and even said that the court should analyze them if a party presents them or if the facts of the case obviously suggest ameliorative measures. The court only had 3 parameters to limit the consideration of ameliorative measures. That was to ensure the child's protected, to not delay the resolution, and to not dive into the custody case. The court remanded the case to the district court on August 31st of 2022. The Eastern District of New York again ordered the return of the minor child to Italy. And the court found that the facts of the case obviously suggested an exploration of ameliorative measures, and that in fact, the judge would have likely nonetheless examined ameliorative measures simultaneous with the examination of whether there's a grave risk of harm in the first place. So finding that a grave risk of harm existed because of the parents' proximity to one another, the court kept in place its original ameliorative measures of a large sum of money to be paid to Ms. Golan, with an acknowledgement that the Italian courts had already put in place a civil protection order. On October 18th of 2022, Ms. Golan was unfortunately found dead in her apartment in New York. Her sister took physical custody of the child and has sought to intervene in the current case on remand before the Eastern District of New York, fighting the child's return to Italy. So the case is still ongoing. Okay, since Golan v. Sada, there have been a few cases where the Supreme Court's new guiding principles have been applied. For instance, in the Southern District of New York, a father who was petitioning for return of his children to Canada argued that ameliorative measures existed to permit the safe return of his children. The petitioner father was found by the court to have certain quote unquote untreated mental health issues, history of domestic violence and coercive conduct, and access and possession of child pornography. The experts at trial tied the petitioner's mental health issues and specifically his past suicide attempts and inadequate treatment to psychological harm to the children. The petitioner offered evidence of 8 separate ameliorative measures, including no contact between the parties, certain therapies, medication, his continued residence with his parents, and compliance with all social service conditions and requirements. Because the petitioner put forth ameliorative measures, the court examined them. That was what Golan v. Sada strongly suggested, that a court should do that. Focusing on the 3 key considerations, the court concluded that the specific measures offered by the petitioner do not prioritize the children's safety and do not address petitioner's history of aggressive behavior and coercive control. None of the measures further protect the children from the petitioner's pedophilia. The therapies and interventions suggested by the petitioner were not geared towards actually treating the problem he has, and there's evidence that he failed to comply with conditions and instructions from social services in the past. So the court in this case refused to return the children even after an exploration of ameliorative measures. Okay, whoops, there we go. Another fascinating grave risk case, which may or should not have been an Article 20 human rights case, was addressed in the Sixth Circuit this year, Salami versus Tascari. Mr. Salami and Ms. Tascari and their 2 children are Venezuelan citizens, and Ms. Tascari removed the children from their home in Venezuela and brought them to the United States in 2018. On February 20th of 2019, Mr. Salami brought his return petition under the Hague Abduction Convention, and on June 10th of 2019, Ms. Tascari and the children as derivative family members were granted asylum in the United States. At the conclusion of the father's Hague trial, the court ordered both children returned to Venezuela. The U.S. Court of Appeals for the Sixth Circuit affirmed. The only argument at trial was whether returning the children would expose them to a grave risk of harm under Article 13b. Ms. Tascari argued that the father was verbally and physically abusive. Venezuela was a zone of war and famine, and the Venezuelan courts were unable to adjudicate the parents' custody dispute. She further asked the court to consider the grant of asylum for her and the children. At trial, the court concluded she didn't meet the clear and convincing evidence burden to prove a grave risk, and the Sixth Circuit agreed. The most interesting part for me of this opinion are the arguments related to asylum. Ultimately, the Sixth Circuit cited the case of Sanchez versus RGL from the Fifth Circuit. And while certain arguments that the mother made in the Hague trial were relevant to her claim of asylum and vice versa, the 2 are really distinct proceedings with very different burdens of proof in the United States. The findings in the asylum matter are not binding on a judge in the Hague Convention case. The Hague court made independent findings on grave risk. They considered all the evidence and applied the high burden of clear and convincing evidence. And in this case, if you read the dissenting opinion, it's very interesting. That judge wrote more about Article 20, which is the human rights exception under the treaty, citing a Canadian Hague abduction case, the 1951 Convention relating to the status of refugees and the Universal Declaration of Human Rights, citing no contracting state shall expel or return a refugee in any manner whatsoever to the frontiers or territories where his life or freedom would be threatened on account of his protected status. It may be that this issue starts playing a more prominent role in future Hague Abduction Convention cases in the United States. And another very interesting Article 20 case, that last case buttresses nicely with this case involving 2 children, ages 5 and 4. Their father retained them in El Paso, Texas, at conclusion of their visit to see him. The children usually live in Ciudad Juarez, Mexico. At the trial on the mother's request to return the children to Mexico under the Abduction Convention, the father argued 13b and Article 20, and he succeeded in meeting the high burden of clear and convincing evidence on both of them, which is very uncommon in the United States in Article 20. More specifically, he argued that the children have special needs, and when they arrived in his care, their physical parents caused him concern that they were being neglected. He said he learned that they were not in school, and the father presented evidence that the Mexican school required the petitioner mother to attend daily with the children to help them with their special needs. But of course, she was unable to do so. She worked during the day. On this basis, the father argued that he observed physical and cognitive decline in both children when they arrived to him. And he further argued physical health issues. The son needed glasses, the daughter needed hearing aids, they wore soiled clothing, they were using diapers when they were with their mother despite being toilet trained, and a physician who met with them even contacted Child Protective Services. When faced with the father's Article 20 argument, the court concluded that the children were not afforded the fundamental right to a special education free of charge to meet their specific needs. The court indicated that the Universal Declaration of Human Rights provides a right to education. The Individuals with Disabilities Education Act establishes a right to free, appropriate public education for disabled children. The Texas Constitution provides for an efficient system of public free schools. And Brown v. Board of Education from the Supreme Court indicated that compulsory attendance recognizes that education is important to a democratic society and one of our most basic public responsibilities. So the judge found that the law in Mexico does provide for special education, but it required the petitioner to be present so the children could attend. And so that effectively denied them their fundamental right to an education, which utterly shocked this judge's conscience. The mother in Mexico has appealed this particular case. So on to the criminal side of kidnapping, because it is a crime under a federal statute in the United States. The defendant in this criminal matter is the father of the minor child at issue. Pursuant to a New Jersey family court order from May of 2017, the father had sole custody of the child with permission to live with the child anywhere in the world. The mother had no delineated access schedule. And it was only access as agreed between the parties. So in July of 2017, the father and son moved to India. The mother sought criminal charges through the U.S. Attorney's Office after he relocated. On October 16th of 2018, the New Jersey Family Court entered a new order directing the father to return the child to the United States immediately. It did not, however, modify the 2017 order, and did not give the mother any custody rights. So on September 27th of 2019, the U.S. attorney presented a criminal complaint against the father. It charged him with one count of violating the International Parental Kidnapping Crime Act. On July 22nd of 2020, a grand jury charged the father on that one count indictment. On October 2nd in 2020, the father was arrested in London on a provisional arrest request. His extradition was delayed when the mother filed an application under the Hague Abduction Convention in England, and the father therefore remained in custody of the London authorities, and the child was a ward of the High Court of London and placed with a foster family temporarily. In the abduction convention case in London, the London High Court found the mother to be deliberately lying and fabricating a case of abduction so she could secure a U.S. green card. It denied her request to return the child, and it then sent the child to temporarily live with the paternal grandparents in India, pending a future reunification with the father. The father, however, was extradited to the United States. The father ultimately sought to dismiss the indictment. The indictment alleged that the father had violated this criminal statute when he failed to abide by the 2018 New Jersey order that said, send the kid back. The father argued that the return order had no delineated parental rights for the mother, nor could the government prove that she had any. The court agreed, and the mother had no concrete, specific, defined rights in a legally binding agreement, and that you have to have clear and certain rights spelled out in the document. Ultimately, the case still went to trial. A jury convicted this gentleman, but on November 29th of 2022, he convinced the court to vacate the conviction. And the argument was that the assistant U.S. attorney had sought an indictment as a violation of the 2018 order with a pure focus on that order, but then spent the bulk of the trial arguing that the 2017 custody order was secured by fraud by the father and completely conflated the two orders. And that was the basis of why the judge overturned the conviction. So I'm sure we'll see additional litigation for this family in the future. Okay, so the Uniform Child Custody Jurisdiction Enforcement Act defines child custody jurisdiction in the United States, except for those of you in Massachusetts. The prioritized way to obtain jurisdiction to issue an initial child custody order is by being a child's home state. A home state is where the child's resided for the past 6 consecutive months with a parent or a person acting as a parent immediately before the lawsuit was filed. The 6 months does not include a temporary absence from the child's home state. And what constitutes a temporary absence really is state specific. There are 3 general tests that are usually used in the United States. And in 2022, the appellate court in Ohio addressed how it would define temporary absence in an international custody case. The Indian national parents lived in Cleveland. Their child was born in Cleveland's a US citizen. The family traveled to India for a family wedding. They had return airline tickets for March of 2018. After several arguments and complaints to the police, the father returned to Cleveland. A few days after that, the mother emailed the father's employer while she's still sitting in India, alleging that the father abandoned her and the child in India. And on March 24th of 2018, she filed an application with the Indian Immigration Bureau to convert the child's visa to an 18-year visa, claiming the father fled to the United States, abandoning the mother and child in India. The visa was extended for 1 year. And on March 25th, the day after, the parties' families got together and held a family mediation without either of the parents and agreed that the father would come back to India on or before April 20th of that year, get the mother and child and take them back to Ohio, but he didn't do that. He claimed he would have done that, but he could not get time off from work or leave in the middle of a particular work project. So on November 22nd, 2018, the mother filed another police complaint against the father, his parents, relatives. She claimed abuse, threats, abandonment, dowry harassment. And finally, in February 2019, she gets back to Ohio and she finds out that the dad had changed the locks on their doors. A couple days later, the father filed a complaint for divorce in Ohio. A temporary restraining order prevented the mother from taking the child out of Ohio and leaving. On February 22nd, 2019, the mother's family filed a criminal complaint against the father in India. It resulted in an arrest warrant. On February 28th, the mother filed a motion to dismiss the father's custody complaint for lack of jurisdiction. He, of course, argued India was just a temporary absence from Ohio, and that the mother was wrongfully retaining the child in India, but because of criminal complaints and no Hague Abduction Convention, he wasn't able to get the kid back. Alternatively, he argued that if there was no home state, that there were significant connections to Ohio for the child, so Ohio should take jurisdiction. The court concluded that India, where the child had now lived for almost a year or had lived, was the child's home state, not Ohio. They found the mother and her witnesses a lot more credible, and they believe that the father did abandon them in India and wanted to come back to the US and live alone. And this revolves around the 3 definitions of temporary absence. Ohio chose to use the duration test. Essentially, the duration test considers short absences to be temporary and longer absences to be more permanent. They thought it provided a much brighter line, and a full year is not temporary. It is a more permanent relocation of the child. Okay, if none of the prioritized means of assuming custody jurisdiction under the UCCJEA apply, the court can determine whether the family situation falls under something called vacuum jurisdiction. And a New York family court in 2022 actually did just that, which is not very common. The parents have 4 children. They lived in Nigeria. The parents and 3 of their children moved to New York. Their 4th child remained in Nigeria, shuttling between relatives' homes because of a visa problem. The mother and father separated after they got to New York, and the mother filed a custody lawsuit in New York family court seeking an order for all 4 children, including the one that was still in Nigeria, and asking that that child be sent to the United States. That child had never lived in the United States. The mother argued she needed the court to intervene because she couldn't leave the United States. She had an asylum petition pending, and so she couldn't go get the child. So the court in September of 2022 concluded it had vacuum jurisdiction and could resolve that fourth child's custody. Complicating the case was that the child's aunt in Nigeria filed a custody lawsuit in Nigeria after the New York court had assumed jurisdiction. So the father then sought to dismiss the New York case. The court ultimately concluded that Nigeria was not the child's home state. Home state, again, is where a child resided for 6 months with a parent or a person acting as a parent. And they determined that the relatives over in Nigeria were not persons acting as a parent under our statute. And therefore, because the mother didn't consent to the child remaining in Nigeria, so therefore the court said that it could assume under vacuum jurisdiction, even though the child had never, ever lived in the United States. The UCCJEA includes provisions that allow a foreign custody order to be easily registered and enforced in the United States. The Court of Appeals of Georgia reversed a trial court that had refused to register and enforce the UK custody order in Georgia under Georgia's enactment of the UCCJEA. If you read the opinion, please don't get lost in the weeds. It misses the mark on certain statements about the law. What it did get correct is that under the UCCJEA, if the foreign court exercised jurisdiction in substantial conformity with our jurisdictional principles, then the order rendered by the foreign court must be registered and enforced short of due process concerns, or that the order was vacated, stayed, or modified, or if, in this case, the UK foreign child custody law violated fundamental principles of human rights. And I'm hoping James will say, no, you don't violate human rights over there in England. In the Georgia case, the mother and child left the UK and returned to Georgia in March of 2017. Mere days later, the Reading County Court issued a custody order related to the child and obligated the mother to come back to England. 2 days later, the parents, by agreement, domesticated the English order in Georgia. The mother then sought permission from the English court to permanently relocate to the USA while she was sitting here in the United States. On April 18th of 2019, the English family court signed a subsequent order, and it permitted the child's relocation, but only until June 22nd, 2021. 4 months before the English family court issued its relocation order, the mother filed a complaint for divorce and primary custody in Georgia, while there was an ongoing custody case in England. In the Georgia complaint, she stated that there were no foreign orders concerning the child that had been registered or confirmed in Georgia. Let's set aside the 2017 English order that the family domesticated in Georgia. The English court actually had not issued its order at the time she filed this lawsuit. So that order that permitted the relocation till June of 2021 had not yet been issued, so it could not have been registered in Georgia yet. So we'll give her that. The father ultimately sought to register the order that permitted that temporary relocation in September of 2020. Aside from whether the English court order should be registered or not is the unanswered question as to whether Georgia should even have jurisdiction over a child custody order when there's a lawsuit that the mother filed in England that was still ongoing. Pursuant to our UCCJEA, England would actually have continuing exclusive jurisdiction to modify its own orders unless and until it decides to decline jurisdiction in lieu of Georgia. So the Georgia court should not have proceeded regardless. If you read the opinion, the father started asserting things like the US and Great Britain are parties to the 1996 Hague Child Protection Convention. This is wrong. The US signed it in 2010, but has not ratified it. Furthermore, don't get confused by the mother's argument that the UK custody order is contrary to public policy, given the father's conduct in the best interests of the child. Georgia did not alter the language of the UCCJEA, so it didn't add in some type of public policy exception. Ultimately, the appellate court determined that the mother did not meet any of her burden for actually contesting this order's registration. So the 2019 UK order shall be registered under the UCCJEA. Once it's registered, it shall be enforced. So I'm going to go through one more case before I get ready to turn it over to James. We spoke a lot about parental child abduction today, but the other side of the coin is a proper request to relocate one's child to another country. That's not necessarily what happened in this case, though, in Gray versus Gray. The Grays were before the Idaho Supreme Court on a case where Ms. Gray unilaterally relocated the party's son to Costa Rica. The parties had an Idaho consent custody order that provided for Ms. Gray, who was living in Wyoming, to have Mr. Gray, who was living in Wyoming, to have access to their son. All access should begin and end at the child's place of residence, which was noted to be Idaho. Ms. Gray then rekindled a romance with a prior boyfriend who was residing in Costa Rica. During the trial, she actually testified that she moved the child down to Costa Rica surreptitiously because if she had attempted to actually ask the father's permission, she knew that he would have tried to stop it. Mr. Gray ultimately found out the child was living in Costa Rica, but only after he filed a motion to modify the custodial arrangement when Ms. Gray stopped letting him have access to the child because the child was in Costa Rica. The Idaho magistrate decided that Ms. Gray was required to return to the coterminous United States with the child, where she would serve as primary residential custodian. And if she didn't return herself, then the child would return and reside with Mr. Gray as their custodian. So Ms. Gray appealed on several points, the most interesting to all of us related to the burden of proof. Typically, when a motion to modify custody is filed, the parent who is seeking the modification bears the burden of proving that the modification is warranted and in the child's best interests. But in this case, Mr. Gray, who was the first to file the modified custody, did it when he didn't even know the child was outside of Idaho. So given Ms. Gray's behavior in relocating the child and keeping that information from Mr. Gray, the court determined that placing the burden on Mr. Gray in this situation is just entirely unfair, and it would provide an incentive to parents to unilaterally relocate their children instead of first seeking to modify the custody order, getting permission to relocate their child. So therefore, a relocating parent should be encouraged to seek permission to ensure the stability of the child before the move is sought, not encouraged to act unilaterally and assert an after-the-fact justification. For these reasons, in Idaho, it's the moving parent has the burden of proving relocation would be in the best interest of the child before moving in violation of a previous custody arrangement. So why did Mr. Gray not use the Hague Abduction Convention by filing a lawsuit in Costa Rica? I couldn't quite tell from the opinion. The opinion didn't provide the full text of the existing Idaho custody order, but one potential issue that might exist is whether or not he had a right of custody under that. There was some brief discussion about Mr. Gray's concerns that the Costa Rican courts and whether there was sufficient access that he could have in their courts to enforce his rights. And in this case, while Ms. Gray conceded Idaho jurisdiction by not appealing, that does not necessarily mean that Costa Rica doesn't have jurisdiction under its own laws to move forward with the case. So there's a whole lot of complicating factors and no guarantee that that child would come back even if an Idaho court said the child's coming back. So I'm going to tie that up here. I'm just putting this up really quick because this is a website where I summarize all of these cases. So you can go there and find all of these and many, many more cases by searching on a key term like habitual residence or something to that effect. Let me end this slideshow and let James take over. Stop sharing. There we go. Go for it.
Lovely. Thank you so much. Let me try and share my screen, which I'm always slightly nervous about, just sharing screens in general. And then hopefully everyone can see me now. Right, thank you everyone. It's a delight to be here. Thank you again, Melissa, for inviting me along. I think, is this our fourth year of doing this on the trot, which is fantastic. All those years ago, we made a reference or a little joke, I think it was on LinkedIn or something, that we were the Meghan and Harry of international family law. I'm not sure if I really want that title now. I haven't read his book, so maybe we'll review that next year if I'm invited back. But anyway, it's a delight to be here. And my job today is to discuss some of the cases that have been going on this side of the Atlantic. So generally speaking, I'm afraid England and Wales, a bit of reference to Scottish law, as well as one or two cases from the European courts. So the menu today in broad terms is this. Some discussions about privacy in the family courts, Hague Convention matters, Hague Abduction Convention matters as well. I'm very reassured to hear as well that the state of Georgia regards English orders as not being violations of public policy and fundamental human rights. Always pleasing to hear. We're also going to be discussing a few of the recent case law from the UK about rights of custody, a consent case, both of two, in my view, are slightly rare to come across in practice. The big A word, asylum, it's rearing its ugly head again. And I was laughing to myself when Melissa was mentioning these asylum cases going through the courts in the US, because we've got a bit of a track record in the UK, and it's been swings and roundabouts, been a bit up and down. And finally, a bit on 13B. And capping it all off, it's just some pleasant issues in relation to transgender children and the interpretation of their laws, and human rights, and ISIS, of course. So where to begin? Let's start with a lovely case, which is a matter of Xanthopoulos and Rakshina. Now, the first thing you might notice about this case is that the parties are named Mr. Xanthopoulos and Ms. Rakshina. As you will see throughout the rest of this presentation, the English system of law generally has initials, or generally Re-A, Re-B, Re-C, and so on and so on. So family lawyers are always struggling to remember which Re-A, the Re-A case reference is being referenced. And the bottom right, you'll see WBH. That's what we're quite used to. The reason behind this case being named is that this judge in particular, who is Mr. Justice Mostyn, goes on to talk about whether people going through divorce proceedings should be afforded privacy. Now, Mr. Xanthopoulos is a very wealthy, I believe he's Greek from that name, gentleman with his wife who's Russian, and they were divorcing in the UK. Now, to put into context, both he had done very well financially, and to put this into context, he had spent, according to the judge, £5.4 million in legal fees between them in 18 months, which is about $6.63 million. And when asked for an estimate of their costs all the way to the final hearing, it was a further £2.3 million, which is about $2.8 million, to be incurred in legal fees alone. So it was a biggie. It was big. So Mr. Justice Mostyn commented that this was beyond nihilistic. The only word I can think of to describe this litigation is apocalyptic. So this is quite a big bugbear of this judge in particular, but he went on to discuss one real issue in particular, which is about whether those going through the family courts in relation to divorce should have their names censored. Should they be known by initials, or should they be known by their names in full? This judge carries out a 60-paragraph narrative on whether divorcees should be mentioned in silence, or whether they should actually be named. He goes as far as referencing section 46 of the Matrimonial Causes Act 1857. This is how up to date we are in the UK. So, we're talking about legislation here from before the American Civil War, but we'll gloss over it. And he goes from 1857 all the way through to the present day about whether this specific issue should be aired in court or not. He talks about how judges did these cases back in the day and how they'd clear the courtroom of the details of the case were very unpleasant, and whether women and children should be, allowed to listen to nasty divorce work. It's all very Victorian, very, very twee. It's quite Downton Abbey. Ultimately, this judge concludes that anonymity is not something that is the default mode of operation. You have to apply for it. He goes on to talk about a blog that he's read about somebody criticizing his own case. So if you ever do have a Mostyn case you want to appraise or review, be careful, because I think he might be reading it. Now, I should say that these are cases in the High Court in general. So for a matter to be in the High Court, it has to be, the overall net assets have to be worth at least £15 million, and the overall net income must be around 1 million. Otherwise, they go to a lower court where these divorces are usually dealt with. But for the big money cases, of which there are many in London, This is something that people need to be very, very aware about. And ultimately, the judge goes through this and says the question is not why is this in the public interest that the parties should be named? Rather, why is it in the public interest that the parties should not be named, i.e. left anonymous? Now, it's interesting as well because those who have lots of money going through divorce, possibly in the UK, will need to know this because in divorce determinations, the financial remedy side, so the financial division of assets, the judge talks about assets, income, liabilities, companies perhaps, your names will be there, your company's names, what positions you hold, where those shell companies are they based in the Virgin Islands or in the Seychelles, etc., etc. It may reference names of new partners, how much money you give them. I think behind this is an undercurrent as well that sometimes these cases need to be kept out of the family court. And I don't know whether intentionally or unintentionally, one of the consequences of this will be it might encourage people to settle outside of courts, or if they just simply can't settle, whether they'd be minded to go through arbitration or mediation. I mean, the detail about arbitration, about having an independent party, is that you basically have a private judge, and no matter what goes on in your case, it's kept out of the public domain. So that's one of the very real advantages of that. That is quite a stark departure from our case law so far, where all the rest of the cases have been anonymized. Another extremely important change in the law came into effect this year, which was the Divorce, Dissolution and Separation Act 2020. That came into effect in April of last year. And our centuries-old traditions of no-fault divorce, of fault-based divorce, have been cast aside, and we have finally moved to no-fault divorce. I remember having this conversation with I think he was a notary in France, who was very wide-eyed at the idea that the notion that we had fault-based divorce in the UK. So the reason behind that is that the applicants in the divorce would have to put forward a fact justifying the irretrievable breakdown of their marriage. These cases were very, very rare, but it was still possible to contest, i.e. defend your divorce, where one party would say, no, I do not think that we should be divorced because I do not believe our marriage has irretrievably broken down. That has all been cast aside and put to bed in terms of history. It just so happens that very, very recently, there's a case that came out from the Liverpool Family Court, a judge called His Honour Judge Greensmith. It's W&H contested divorce, where because the divorce petition was introduced before April 2022, the older laws from 1973 still applied. And ultimately, that judge in that case says that it follows from my observations, I am unable to make findings supportive of the element of the husband's behaviour, which would meet the test in order to say divorced. I am not satisfied that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. I don't think we'll see many more of those cases in future, probably for good reason, now that we've moved away from fault-based divorce. If the applicant in that case had applied now, then they wouldn't have to demonstrate this process of fault-based divorce. Very, very interesting development in family law, and thankfully these contested divorces may well be put to down in the history books, at least thankfully in my view. Separately, another issue just tied into the element of privacy in the family courts. Now, there is a long running case, which is Mohammed bin Rashid Al Maktoum against Princess Haya. So for those of you unaware with Middle Eastern politics, Mr. Rashid Al Maktoum is the Prime Minister of the United Arab Emirates. There have been no less than 15 reported judgments by the president of our family division, our head family judge, all in relation to this family. These judgments have ranged from custody to phone hacking to his potential diplomatic immunity, financial issues, risk of forced marriage, and so on. It's been blockbuster. Sooner or later, if I were a betting man, I'd bet that there is going to be a film about this, or at least a good drama series coming out on Netflix in relation to this. And the findings of the High Court have been damning. It was extraordinary domestic violence. I mean, some of the findings include that he had abducted and confined 2 children, so Princess Latifa and Princess Shamsa, one of them from the streets of Cambridge in the UK, and took them to the UAE. Subjected the mother to a campaign of harassment and intimidation. He had hacked their phones. He had hacked their lawyers' phones. He had attempted to buy a sizable property next door to the mother's property in Berkshire. He was a very significant threat to their security, and so on. Now, the reason I raise this is because whilst it is highly unusual, not only for a welfare judgment, so for a child custody, essentially this is a child custody, ultimately, determination, it is highly unusual for a case like that to be put in the public domain. The judge comments in his decision that when he was writing that judgment, he had never intended it for it to see essentially the light of day, and that it was going to be private to the parties and their lawyers. He said he did so on the basis that this family in particular, their names are well known, and this is important for this man who is very influential, for the mother in that case, to be able to put her accurate story available for public scrutiny, and to avoid the father being able to promote a false narrative. But it's not just cases of sort of the 0.01% of the population in terms of their wealth and their influence who have where this issue of privacy is engaged. So the second case is a decision of Mrs. Justice Judd, and that's a case of B, R, and G, who were 3 children. It's a very, very tragic case where G was a child whose sibling E died in 2020 in suspicious circumstances. There was not much activity, and then 2 years later, both parents were charged with her murder, and the criminal proceedings are ongoing. They have been kicking around for some time. So social services in that case had placed that child, the surviving child, put the child in foster care. Now, the issue about this was whether there was a public interest in the family being named. The local authority, social services in this case, had applied to the court for an injunction for the details of the parents to be, and the whole family to be prevented from going into public domain. This caused quite a stir. The BBC, ITV, The Times, and associated newspapers all attended courts seeking to defend the application for prohibition. And ultimately, the judge had to balance, on the one hand, the child's right to a private life, which is Article 8 of the domestic 1998 Human Rights Act, and Article 10, which is the right of the press to have freedom of expression, and so on. In what I thought was slightly surprising, the judge refused the application and allowed it to be put in the public domain. The judge said that, if I can just pull up the quote, there's no particular evidence that the reporting would have an adverse impact on the search for this child or a search for future adoptions, and saying the name of the child who had allegedly been killed is an important part of the report in any media, as are the names of the defendants. Without these names, the trial would become disembodied. So that's why the judge had allowed it. We are seeing generally, not just in divorce and not in these 2 extreme cases, a move in the family court of openness and transparency, which is something that in the next coming years we may see more and more. We have lots of working groups at all levels of the family court, in which the principle of an open court is one that's held in very high regard. There have been many, many years of the family court being seen as very secretive, and certain successive presidents of our family court have been really trying to be seen to do something about that. And these are just 2 cases on that point. So on a completely different note, let's move over to some Hague cases. So these are 2 Hague cases involving rights of custody. I should say at the outset that Hague cases, as common as they are in the UK, rights of custody cases are exceptionally rare. We in the UK have a very, very wide interpretation of what constitutes a right of custody. It is, in my experience, very rarely challenged, and people just take it as given. So when our central authority receives cases, they will ask for a statement of the right of custody. The lawyers for the left behind parent will put that statement on rights of custody into the originating application, and it, generally speaking, it's sort of just taken as for granted. A lot of judges think, well, if not, this would have been filtered out at the stage of shifting between the central authorities. But these two cases do stand out. So the first one is the case of K&N, which is an abduction from the Republic of Ireland to the UK. Now, in this case, it was a father who the father and mother were not married, and there was a child born in Ireland. The child was undoubtedly habitually resident in Ireland, and the father wrote to the mother saying, please, can I have what the Irish call guardianship, which we would call parental responsibility, or some sort of custodial right or right of custody as per Article 3 of the 1980 Hague Convention. So the father wrote to the mother, no response. There was some suggestion that the mother may have been a bit slippery about receiving these papers. Attempts made to serve the mother were unsuccessful. And then on the 9th of February, the father applied to court. Lo and behold, on the 10th of February, the mother had left Ireland and travelled over to the UK. She did not know, she stated, that there were any proceedings kicking off in Ireland. The father then went on to gain custodial rights in the form of guardianship from the local Irish courts in April 2021. But by this point, the child had been in England for some time. The father applied under the Hague Convention for the return of the child, and it was found by the judge that this father had only acquired rights of custody after the child's removal. So looking at the dates, there's not much in it, and I do wonder whether the father writing to the mother seeking joint guardianship kicked the mother into leaving some 8 days later. The judge refused the application for the return of the child to Ireland, and you could tell that he was quite unhappy with not only the mother's actions, but his own decision, in that he writes, this is in many respects an unsatisfactory outcome in circumstances where the mother's actions constitute a clear act of child abduction. It is uncomfortable in other circumstances whereby the result would have been different if the mother and father had been married. The judge makes reference to Professor Lowe's work, International Movement of Children, for 2016, and does say that the judge does acknowledge that whilst there are advantages in a flexible approach to what constitutes rights of custody, it is important for, in order to regulate their lives, citizens are entitled to be able to ascertain their rights and obligations with some degree of certainty. I raise this because of as I say, the UK has a very sort of wide berth when it comes to custodial rights, and that's why it was quite surprising in some respects to see this judgment. Now consider it conversely, which is a case of BNL, the second case on the right of the screen, which is a removal to Poland. And much like Irish law, if parents are not married in the UK, a child is born at least in England and Wales, and if the child's father is not named on that birth certificate, that father does not necessarily have automatic parental rights, or what we would call parental responsibility. Now, in that case, was slightly different. This was an outward abduction from the UK to Poland. They weren't married, and the mother did remove the child whilst they had been discussing things. The father had a relationship with the child, although he was not on the birth certificate. He was engaging with this child's nursery and healthcare. He was paying child maintenance. He was seeing the child fairly regularly. The mother had run off to Poland effectively, and the father had started proceedings in England. And this judge, Mr. Justice Cobb, was asked to make an Article 15 declaration, which is a declaration as to the nature of a wrongful retention or other custodial rights as per the 1980 Hague Convention. So in this case, the judge held that this father had some rights, i.e. inchoate rights. And this is something that is found in certain jurisdictions, especially ours. There's a recent Northern Irish Supreme Court case on this very, very issue, where you can have rights of custody even if you don't have a sort of legal rights. It's an inchoate and incomplete right of custody. And the father was found to have inchoate or some rights of custody because he had been spending increasing time with the child. He had spent time with the child alone. He was engaged in the child's nursery, involved with the child's health. He was paying, and the mother and father, the parentage wasn't disputed in any way. It was more the fact that the father was going to, they had agreed that the father was going to play a full role in the child's life until she abducted to Poland. So on that basis, the father, a declaration was made, and that I hope, for this father's sake, would give the father some assistance in any future proceedings in Poland. So it is possible, even if you don't have parental rights, for to have some sort of custodial rights in this respect. Moving on to another case, which is a Court of Appeal case. This was a matter in which the mother had brought a young child to the UK. The father had said this was without his consent, and the father had sought for the child's return from England to Spain. The mother was British and the father was Spanish Moroccan. This matter went before a Deputy High Court judge who, when dealing with this issue, refused the application made by the mother for there to be oral evidence. Now, generally speaking, oral evidence, i.e. where you have a parent testifying in the witness box and ask questions, is very, very rare in a Hague Convention case. You only always see it pretty much in consent cases or acquiescence cases. You wouldn't see it, for example, usually in an Article 13b case or a settlement case. The judge in that case, however, refused the application for oral evidence in that case, and this went to a Court of Appeal. And then the Court of Appeal held that consent is an issue of fact in respect of which the court has to make a finding. It is a binary issue of fact. Now, the Court of Appeal has said that oral evidence needs to be strictly limited, so you can't open up and ask questions about domestic violence and habitual residence, generally speaking, or 13b. You can only really do so fully limited on the basis of this consent case. Now, the reason behind this being particularly important was because the mother and father said that they were having discussions about moving to England, but there was no real sort of physical proof or paper trail. It was a question of he said versus she said. And that's the reason why the Court of Appeal felt that it had to intervene. And then it went on to restate the issue about 13b. There was some suggestion that the lower judge didn't adopt the correct test. And those involved in the Sada and Golan case will be very pleased to hear how we deal with it in the UK, which is take the allegations at their highest. But in cases where allegations of domestic violence, the court must ask, firstly, if they are true, is there a grave risk, and then assess how the child can be protected against that risk. Just a useful recap on that very common issue, as Melissa's already highlighted. Over the page, the lovely issue of asylum. So here we go again. So last year, fans of international family law will know that our UK Supreme Court heard a case about the return of a child who had applied for asylum. That G&G case involved a mother who had brought a child over from South Africa. She identified as a lesbian and said that she faced persecution from her family in South Africa. And the state there was just unable to protect her. And this went to the Court of Appeal and then on to the Supreme Court, which held that the Supreme Court allowed the mother to appeal and held that a child who had been had made an application for asylum cannot be returned to the country from which he or she has sought refuge before the final determination of their asylum claim. Now, the reason behind this is that it's very, very important to talk about timing in this sort of situation. So in this case of Re R, this involved a Ukrainian family, and I should highlight as well that this is the first half of 2022 before the Russian invasion. So the reason behind asylum in this case is not to do with the invasion of Ukraine. So this mother, she was a bit of a wild card. She was a repeat offender. She had abducted from Ukraine to England. The English court has sent her back to Ukraine. She was in Ukraine for about 15 minutes before she went back to England. She had abducted twice, a two-time offender. On the second go, she had been ordered to return, but once she had come over to England, she made an application for asylum for herself and for the child. Now, the judge effectively said at first instance, well, she's made an application for asylum and she's been granted it, and it's pending, so I can't really do anything, so just flat out dismissed the father's application for a Hague. Now, what the Court of Appeal has held in quite a lengthy but very, very important judgment in this case is that whilst a successful application may impact on the implementation, i.e. the execution of the return order, which is the child returning to Ukraine in this circumstance, it does not act as a bar automatically to such an order being made or dispensed in the first place. So you could get the order for the return, but it could be refused if the person involved gets asylum afterwards. The reason behind this as well is that if there is a pending asylum process, it might be that the left behind parent wants to make representations to the UK authorities about whether the asylum is a valid claim or not. There are circumstances where the Secretary of State for the Home Department, who is the organisation of the body in the UK that deals with asylum claims, where you can have your claim for asylum revisited or revoked. So it becomes this sort of cat and mouse situation where you try and rush a case through on the abduction side in order that you can get a return order, stay the return order, and then send that to the asylum authorities in the hope that that will torpedo the respondent's asylum claim. It is getting a bit silly, for want of a better word. This is becoming more and more common, and there are some horror stories out there where, so this is South Africa, which is very different. There's another case of a non-Hague abduction from North Africa. The country is anonymized, where this is also coming into effect, this issue. There are some other cases where those people who abduct and do not want to be sent back use this as a tool to delay, frustrate, prolong things. So I'm aware of a case involving Singapore where a mother abducted from Singapore and she claimed asylum here. Considering the system of law in Singapore is based almost entirely on English law, it's, well, I don't want to make any further questions about it. There are similar cases involving a parent who's abducted from Spain and claimed asylum, from Italy who's claimed asylum in the UK. And the one that raises the most eyebrows perhaps is a child who was abducted from California, brought to London, and the parent who had abducted the child made an application for asylum, preventing return to the USA. These cases go on for an enormous amount of time, well over the 6-week window. This is really something to watch for, and when you see you see judges talking about these applications being sham claims for asylum, with a view to delaying and frustrating things in as much as impossible. And that's why timing is of incredible importance, because then you can get the return order, send it to the authorities, and hope that they will not be granted asylum. So that is that. So this all comes under the banner of 13B. I want to talk about one more case on the 13B front. And at first blush, before I go on to that slide, at first blush, it might sound like just a regular, boring, run-of-the-mill Article 13B case. So in that case, the child comes over for a stay in the UK. The parent seeks to return home after a long stay in England, a fairly long stay in England, and is stopped by the other, and Hague Convention proceedings kick off. It's a European country, but it's all about 13B. And at first blush, it doesn't sound like much of a big deal until we do talk about it a bit more and realize it's got to do with the Ukraine. So by way of background, I'm sure nearly everyone here is going to be aware of it, but just for context, following the invasion of Ukraine by Russia, some 8 million people have fled Ukraine, mostly to Poland, some to Germany, and there are about some 150,000 Ukrainian citizens in the UK. What isn't really discussed much in the media, as far as I'm aware, is that a lot of Ukrainians have actually started returning to their country. I acted for the mother in this case, and in this case, the mother wanted to return to Ukraine with her child. It was the initial panic of leaving Ukraine, and then speaking to her family left behind, and then realizing they're all faring fairly well, and that life's going on there. Some miss their families, some feel guilt for leaving, and so on. That's an issue for another time. But in this case, the mother had come over with the child in April 2022, and considering the war started in February 2022, some months later, and she wanted to return to Ukraine in June 2022. The father issued an application for an order prohibiting the child's return to Ukraine, and the mother cross-applied under the Hague Convention. So she said that the child had not become habitually resident in Ukraine, in England, that the child remained habitually resident in Ukraine, and sought to return there as much as possible, as swiftly as possible. The father defended the application on the basis of 2 fronts, the first one being habitual residence, and the child having changed habitual residence in a matter of, say, 8 weeks. So unsurprisingly, that was dismissed fairly rapidly. The more complex defense that the father tried to deploy was that of 13B, unsurprisingly. And his was focused around the issue of war the invasion, of course, the threat to life. The judge analysed the risks to this child if this child was to return to to his home city, which is, for context, near Uzhhorod, which, if you see the R in Romania, it's just directly north of there. So it's on the border with Poland and Hungary and not too far from Romania. On the day of the hearing, we received news overnight that Putin had mobilized some 300,000 reservists, which really didn't do the applicant's case any favors, but still we fought it. The judge went on to analyze the risks posed in general in Ukraine. And there are some sound bites in this judgment, which I don't think I will ever see in any other Hague Convention application, including this judge saying the banging of the nuclear drum by President Putin is not to be taken lightly. The possibility of nuclear power plants being damaged by military action, contaminating the Ukraine and beyond, as occurred with Chernobyl. It goes into detail for some time. Ultimately, the judge ordered the child's return to Ukraine, which I'm sure certain amongst us will find surprising. In doing so, the judge analysed that the town was near the Hungarian border, the mother was a Hungarian national, so she could, and the child was as well, so the child could easily enter Hungary if they so wished. The mother gave an undertaking, a protective measure, our favourite word, our ameliorative measure, to leave Ukraine if fighting went into a certain part of the territory. And the judge noticed that there were no hostilities for 100 miles to the child's hometown. The judge said that schools were open, life goes on, courts were open, etc., etc. He said that the town was of low risk of military attack, as there were in particular no military installations in the town or any business like that. And so for that reason, the judge was minded to return the child to Ukraine. Anecdotally, there might be a suggestion that the English courts were becoming slightly weak about returning children in certain circumstances, finding 13B in the last few years a bit more than they did so maybe 5 or 10 years ago. I'd like to think that this case might cause people to reevaluate that. It caused a bit of controversy online, but when you actually drill down into the nuance of it and what this child was going to be experiencing in that specific part of the country, the risks in the judge's view were reduced to the point where Article 13B did not apply. With the huge exodus of population from Ukraine, I doubt this will be the last case involving a Hague Convention application involving Ukraine, but we shall see where it goes. I would love to know in any other jurisdictions if you have found a case involving the Ukraine of this nature. And that's that. So moving on away from Hague is a further issue, which is one that is bubbling over to the point where there was news today on this very issue. So at least you're being appraised up to the moment on this particular issue. So this is all about gender recognition, which might sound a bit left field, but bear with me. So at the moment, people in the United Kingdom can apply to change their legal gender and apply to a UK gender recognition panel. To do so, they can do so on the basis of having a medical diagnosis of gender dysphoria. You need medical reports in support of that, and to have lived in that gender for some 2 years. The Scottish have seen it fit to change this, or well, not change it rather, but put in place their own system. Now, the Scottish Parliament is able to make its own laws in very specific areas. They're called devolved areas, such as schooling and health and some issues of tax, etc. And the Scottish Parliament is able to legislate accordingly. And what they have done is brought in this bill, which was controversial in Scotland in itself, but passed. So the Scottish Government have passed this legislation which entitles applicants to apply to a new panel, which is a Registrar General in Scotland, where they will no longer need a diagnosis or medical report, which would be required. The period in which they need to have lived their acquired gender would be cut from 2 years, as in the rest of the UK, to 3 months. And perhaps the most controversial all of it is that the minimum age has been dropped from 18, as it is in the UK, to 16 years of age. There are certain other cases of children younger than that seeking permission to receive hormone blockers, etc. As I think we discussed this last year, and it's changing very, very rapidly. But this is what the Scottish are trying to introduce. The Scottish Parliament has passed this legislation, and the UK has, the Westminster Parliament has now said that they are going to veto it effectively with what's known as a Section 35 order, vetoing or striking down legislation made in Scotland. This is the first time since these powers were given to the Scottish Parliament in 1998 that this order is being made. And it comes on the basis of a very, very fractured relationship, or an increasingly fractured relationship, I should possibly say, between Edinburgh and Scotland and London, because of following Brexit referendum, where the majority of Scotland voted to remain but had to be dragged out of the European Union, and the murmurations of a second referendum, which is in Scotland, about whether Scotland should be asked to seek independence. Just by way of even more additional background, the Scottish Parliament did try and launch a second referendum, but that was denied by our Supreme Court, which said that they didn't have the power to do so unilaterally. All I would say on this front is watch this space. The First Minister for Scotland in London was saying that he had to reluctantly veto this bill, and Nicola Sturgeon, who is the First Minister for Scotland, described this today in a tweet as a full frontal attack on democratically elected Scottish Parliament and its ability to make its own decisions. Watch this space. It's a bit straying left of family law, but there is still this element because of the 16-year-old age, if you indulge me on that. It might have wider constitutional impacts. We'll see where it goes with this, and it's in my view slightly tragic that this very sensitive issue can be seen as one being used for political sort of bartering or gain, with Westminster trying to be seen as tough and Scotland trying to be seen as independent. So watch this space is all I can say on that. And finally, the European Court and involvement with ISIS. You might think at first blush, well, why on earth do we need to think about this? This is something that the Children's Rights Observatory in the University of Leiden has described as morally disturbing and politically toxic. This is where many citizens from countries in Europe, and indeed outside of Europe, travelled over a few years ago to ISIS-controlled Syria and the surrounding area in order either to fight for ISIS or join husbands and wives there. So it was understood that I researched this morning. There are about some 900 Brits who left the country to join ISIS. Many remain unaccounted for. There's about 1,300 French citizens, 400 Belgian citizens. Many have had children in this ISIS-controlled territory, and many have had their citizenship revoked. There have been. This is quite an extreme measure, but there is some circumstances whereby some of these children are being born, and there's a risk of them being born stateless. What European governments are now facing is a situation whereby they are trying to work through the idea of repatriating their citizens from Syria to their countries. In France, this is the case that went to the European Court of Human Rights. The French were describing it on a case-by-case basis. There were 35 children repatriated from Syria to France. They were granted on sort of a haphazard way. Some were granted it, some were not granted permission to repatriate, or were granted assistance to repatriate. Certain children were left behind, certain family members were left behind, and in the case of HF and others, their parents or their grandparents in France sought to claim that the individual rights of the citizens were breached by the French government's failure to repatriate them in particular. The situation in the camps is undoubtedly seen as appalling, and the European Court discusses that in quite a lot of detail. But the question becomes, is there a positive obligation on these governments to repatriate their nationals? The European Court of Human Rights has said there is no positive obligation to do so. There's also a lot of talk about jurisdictional links, about whether the French are responsible for something that their citizens did in a country that is outside of the territory that is outside the French courts. But on a more narrow and I would say perhaps more boring issue, the European Court has said that the French system violated their rights because of the process was seen as very arbitrary, and there was no proper setup as to the claims and how they are analysed, or an appeal process. This is going to have wider implications, I believe, because there are certainly cases of children going who have been born there in particular the Al-Hol camp, which is one of the most sizable camps in Syria, where they have sought to be repatriated, especially in the UK. There are cases going through the High Court at the moment. So maybe this time next year, we'll be talking about the next stage of that. Separately, and just to conclude on it, the UN Committee for the Rights of the Child, they have found in two very, very recent decisions that in contradistinction to the European Court of Human Rights, the UN has found that this actually has violated the best interest of the child and the right to life and the prohibition of torture, all found in the Convention of the Rights of the Child. I realise I'm preaching to a bunch of Americans about the UNCRC, but we'll gloss over that. The UNCRC committee has also found that there was an obligation on France to repatriate its children held there. And it's not just France. Finland has also been subjected to exactly the same conclusion, which came out this month. 33 children who had Finnish citizenship, they had sought to be repatriated, and their refusal was held to be a violation of their basic human rights. And really, if the Nordics can't get the human rights angle correct, then I don't know what the rest of us are dealing with. But this is quite an ugly background of using children's rights in a very difficult situation, and I can't imagine the UK is going to be rushing in there repatriating its own children easily, but there are certainly cases in which we will see this coming out in future. So again, much like the transgender issue, but for very different reasons, watch this space and we'll see where it ends up with, and maybe this time next year, as I say, we'll be discussing this once again. And on that note, I think I am done. If anyone has any question about any of these cases, feel free to drop me an email. I saw there was a question about the slides being shared, sorry, so we'll see. I'm happy to share them. Melissa and I can drop them out if the ABA don't. Yes. But
the ABA has indicated to me that they'll share our slides, and there'll also be a recording so that you can listen to James's dreamy British accent all that you want. But thank you so much for joining us today. Thank you, James, for doing this before you have another meeting that you have to go to this evening. But I'm really grateful that we got to do this for a fourth time in a row, and look out for this again next January. I guess we'll do 2023's craziness.
Looking forward to it. Thank you, everyone.
Thanks. Happy New Year.
Cheers. See you, everyone.